Hello, everybody. Do 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 do. Here's the ticker coming across just like CNN does. A little bit corny. Here we go. Today's video is questions you should never answer at trial. Please stand by. Please stand by while more viewers join us. Remember, today's topic is brought to you by me, Gerry Oginski. Unsponsored, and if you want more information, stick around, because here's what you're going to learn in today's video. Questions you should never answer at trial. Please stand by while we move this corny piece of paper across the screen, just like CNN does on the lower third ticker. Right? Here we go again. Great. We're going to hang on until a couple more people show up, and then we're going to go ahead and tell you about questions you should never answer at trial. Please stand by while I continue to move this around in a very corny fashion. Hey, Brian, how are you? Nice to see you. As you notice, this quality image of a ticker going by just like CNN. Questions you should never answer at trial. And I'm sure Brian can chirp in because he's an excellent trial attorney in California. So thanks for joining me, Brian. I know it's 3 hours earlier over there, so it's probably bright and early morning. Here it's midday. It's a gorgeous day here today in Great Neck, New York. And I wanted to share some great information with everybody today so that they have a clear understanding of not just many questions, but I'm going to focus on 2 questions that you should never, ever answer at trial. Okay? It's very important for you to understand the 2 key questions that you should never answer at trial. All right. So welcome, and thanks for joining me. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And today I am talking about questions you should never answer at trial. Okay? No need to stand by anymore because we are live here on Facebook video. All right. Well, welcome, everybody. I want to share this great information with you because I want you to understand that there are 2 questions that you should never, ever answer during a civil trial, at least here in New York. And I'll tell you what they are in just a moment. And by the way, this also applies. Hey, Scott, nice to see you. This also applies during pretrial testimony, known as a deposition. That's a question and answer session given under oath in the attorney's office, where now you're being asked questions in anticipation or preparation for the upcoming trial about a year away. So, let's go through it again. Questions you should never, ever answer at trial. Now, you should know something very important. In these civil lawsuits, that's like a disappearing act. I disappear off camera and come right back. All right, in these civil lawsuits, we have to go through what's known as the discovery process. And that gives the other side, the defense, an opportunity to learn information about us, learn information about our claim, learn information about what it is that we are claiming and alleging in this particular case. We are obligated to give certain documents to the defense. And those documents will help the defense understand your claim. So in a medical malpractice case, for example, we want to be able to show that, number 1, the doctor whom you are suing or the hospital staff was careless. And number 2, that the wrongdoing was a cause of your injury. And number 3, that your injuries are significant and permanent. And all of those things have to be confirmed by a qualified medical expert who tells us, yes, your doctor was careless, his carelessness was a cause of your injury, and yes, your injuries are significant or permanent. So now, during the course of the lawsuit process, the defense lawyer, the attorney representing the doctor whom you have sued, will have an opportunity to question you during that pretrial question and answer session known as a deposition. And now, during the course of this question and answer session, which takes place in your attorney's office, in fact, in his conference room, by the way, you should know that during this deposition, there's no judge present, there's no jury present, but instead there is a court reporter there to record all of the questions and all of your answers. And all of that information gets transcribed into a booklet called a transcript. And that information can and will be used against you when your case gets to trial. So that's very important to understand. And if you're joining me and you want to know what we're talking about today, today's topic is questions you should never, ever answer at trial or deposition. Okay? And I'm focusing on, hey, Jordan, nice to see you. And I'm focusing on 2 specific questions. And it's going to be very clear why you should never answer those types of questions. So questions you should never be asking at trial or during your pretrial question and answer session. Thanks so much, Jordan. I'm glad you're with me today. So now, during the course of questioning, the defense lawyer will have an opportunity to learn lots of information. And he might be asking questions that are inappropriate and have nothing to do with your particular case. But you know something? Because this is discovery, he's permitted in New York to ask you questions that you believe have nothing to do with the issues in the case. He might be asking you things off-the-wall questions, questions having nothing to do with your claims against the doctor, questions having nothing to do specifically with the damages and the injuries that you're claiming. But the reality is, because this is discovery, you are required in New York to answer those questions, except for 2 questions. And you want to know what they are? Okay, I'm going to tell you in just a second. But this applies also at the time of trial. So now when you're at trial and the defense attorney is asking you those same questions, many of those questions, if they are not appropriate, at least I, as the attorney, have the opportunity to jump up out of my seat and say, "Objection, Judge, that's irrelevant." And now the judge can make an instant decision about whether or not what I am saying is true. And if, in fact, this has nothing to do with the issues in the case or the defenses that the doctor or hospital staff is raising, then the judge will stop the defense attorney from asking those questions. But now here's let me try it again. Here's 2 specific questions that are going to arise that under no circumstance should you be answering. The first question is, "Hey, Mr. Jones, isn't it true you spoke to your attorney before I'm questioning you?" Well, he can learn the answer to that question. Yes, of course it's true. "Tell me, Mr. Jones, what you and your attorney talked about before I got to question you." Objection! That's privileged information. Amazing, isn't that? That's the question that you are never to answer. Why not? It's because any conversation that you have with your attorney is confidential. We call that privileged, which means the defense attorney can sit there for days and days and weeks asking over and over again, "Hey, tell me what you and your attorney talked about." And the reality is that under no circumstance are you to disclose the information that you and your attorney talked about. Now, people who don't understand the attorney-client privilege may turn around and say, "Hey, if you've got nothing to hide, why not just tell us what you guys talked about?" Because they think that you're trying to hide behind some type of wall, right? They think that you're trying to hide behind something that does what? That prevents them from learning information that will help them in defending the case or in bringing the case. So, when the attorney turns around and says, "Hey, what did you and your attorney talk about?" And I'm just using this mini bat as a metaphor, okay? Not real, not used at deposition or trial, but just as a metaphor. When he badgers you into asking the question, "Hey, tell me what you and your attorney talked about. If not, I'm going to beat you over the head." No, no, no. That can't happen. Your attorney has every right to jump up and say, "Objection! That's privileged information." And you know what? He's absolutely right. And if this were to take place at trial, your attorney would have every right to jump up out of his seat. As if you press an ejection button, you'll notice the attorney jumps up out of his seat and says, "Objection, Judge! That's privileged." And the judge would then be absolutely correct to turn around and get his microphone out. Now, to turn around and tell the jury, "You're absolutely right, counsel. Objection sustained," which means, defense attorney, you can't ask that question. And the witness, you are not to answer that question. And in all likelihood, the judge is going to turn to the jury and tell them that because attorney-client privilege, because communications with your attorney are confidential, anything you say to your attorney, anything he says to you, is private and cannot be disclosed. So that is one key question you are never to answer during a deposition or at trial. All right? So I'm going to take a quick unsponsored water break right here as we continue on with today's topic, questions you should never answer at trial. So please stand by while I grab my Poland Spring water. They should pay me for this, because here I am drinking their water on camera, getting a nice thirst-quenching drink. Yes, it's true. Poland Spring is the drink that I drink, and they are not paying me for that. Outrageous. How dare they? They should contact me to sponsor this video. All right, so here we go again. Remember, we are here talking about questions you should never answer at trial. And here's my ticker tape topic of the day. Now you've stood by, right? Thanks so much. All right, so now we're at the second question you should never answer during trial or during a deposition. And the second question, Here we go. The second question you should never answer is, you are now on the witness stand. We're at trial. The defense lawyer is now questioning you on cross-examination. And now, what does he say? He says, hey, you son of a bitch. No, he doesn't say that. Instead, he turns around, and now, instead of asking you questions about the issues in the case, excuse me, 1 second. Instead of asking you questions about the facts of the case or the claims of the case, or instead of asking you about questions about your damages and the injuries you sustained, instead, he comes right out and he says, hey, Mr. Jones, how many times did you beat your wife last night? What? What? How many times did you beat your wife last night? Well, number one, that assumes a couple of things. Number one, it assumes that he's married. So, assuming that he's married. Number two, it assumes that he beats his wife. Number three, it assumes that he beats his wife at night. Could you imagine that? How crazy is that question? It's got nothing to do with the issues in the case. It's got nothing to do with anything, not with the damages. But the defense attorney might turn around and argue that it's a collateral matter, that the jury should be entitled to know about this guy's propensity to beat up his wife at night, as opposed to any other time, assuming that's what he does. Okay? That is an outrageous question, having nothing to do with the issues in the case, having nothing to do with the facts of the case, having nothing to do with anything. Now, I am going to assume also that this defense attorney has a good faith basis upon which to ask that exact question. And maybe he does. Maybe you've had a history where now you've had some domestic abuse, and now you were arrested, and that's a clear public record. So if he has a good faith basis to ask that question, okay, now he may be able to get away with part of the question. I'll tell you about that in a moment. But for most people who don't have that type of history, and now he gets up at trial and cross-examines you, and he turns around and says, hey, Mr. Jones, how many times do you beat your wife each night? Whoa, that is outrageous. That is so palpably improper. And you will notice when that happens, your attorney is as if you push that ejection button out of his seat and it springs right up, boing. He's going to jump right up, yell out, objection, Judge! That's palpably improper! And you know what? It sure is. It is palpably improper for him to ask such an outrageous question, because now that type of question will inflame the jury. The jury doesn't know anything about this guy's history. The jury doesn't know whether what this attorney is asking is true or not. And by simply asking the question, it automatically suggests or implies to the jury that, number one, this guy beats his wife. Number two, he does it at night. And number three, it somehow is related to the claims being made in this case. Isn't that fascinating? So in that instance, the judge will be well within his right to turn around and say, you know what, counsel? Objection sustained, which means you cannot ask that question. And Mr. Witness, Mr. Jones, you are not to answer that question. That's what it means when a question is so outrageous, right? Questions never, there we go, then never to answer at trial. You have to wait to hear whether or not the judge permits you to answer that question. And that is such an outrageous, off-the-wall question that it does not require an answer. Now, it would be kind of embarrassing and really awkward if the judge were to turn around after the defense lawyer says, hey, you know what, Judge? I have a good faith basis upon which to go ahead and ask this question. It goes to his credibility. Well, if it really goes to his credibility and there are issues here about maybe his mental status, issues about his outrageous bursts of, anger, then maybe, just maybe, the judge will turn to the witness and say objection overruled, which means that even though the attorney has objected to this question, the judge, hey, Stephen, nice to see you. We're talking about questions you should never, ever answer at trial, okay? You don't have to stand by, you're with us, but I'm talking about questions you should never answer at trial or during a deposition. And the first one, just to recap, was questions that are privileged, where the defense attorney is asking about confidential discussions between you and your attorney. And now we're up to the second question you should never answer at trial, and that is a question that is so palpably improper. And Stephen, you'll know this, coming from a criminal law background, where you represent people who are hey, Alan, nice to see you, where people are brought up on charges for criminal conduct. The next question is, hey, Mr. Jones, how many times do you beat your wife each night? That's an outrageous question. That's palpably improper. And the judge would be within his right to turn around and say, objection sustained. Counselor, you can't ask that question. Mr. Jones, you cannot answer that question. You are not to answer that question. But if, now we're taking the other extreme, if the defense lawyer has a good faith basis to justify asking that question, and the answer might impact on his credibility as well as the claims that he's making in this medical malpractice case, then maybe, just maybe, the judge is going to turn to the witness and say, Mr. Jones, you have to answer that question. Even if you don't want to answer that question, now you've got a problem. Now you've got some really awkward scenario where you're bringing a claim against your doctor, claiming that he violated the basic standards of medical care, causing you harm and injury, and now this defense lawyer has pulled something out of your background. He's got a document here showing that you were arrested, you were convicted, or you pled guilty to some crime involving some type of spousal abuse, and now he wants the jury to understand who you really are. He wants the jury to know that you're not an upstanding citizen, and he has every right to do that if he can show that they are somehow related or it affects your credibility, and the jury needs to know it when you're testifying about these claims against the doctor. Very, very interesting question. But for the most part, most people do not have spousal abuse claims that are verified and have been, you pled guilty or you were convicted, and now the question never to answer at trial is an off-the-wall, outrageous question where now you're stuck. And that's a position you don't want to be in. But for the majority of times, the judge is going to turn around and say, objection sustained. Defense lawyer, you can't ask that question. You know it's improper. Mr. Jones, do not answer that question. Move on, counselor. And those are the two key questions you never are to answer, at least here in New York, in a civil lawsuit involving accident matters, medical malpractice matters, and even wrongful death matters. So why do I share this quick information with you? I share this quick information about questions you should never answer at trial to give you an understanding of what goes on in these civil lawsuits here in New York. And I understand you're watching this video because it came up in your Facebook feed on a beautiful day today, and you're interested, the title got you interested, and now you started watching, and now you learned some great information, or you're watching this on the replay, and now you're actively searching for this information. Maybe you're a litigant, or maybe you want to learn more about how your type of matter works, and now you've come across my video about questions you should never answer at trial. Well, let me share something with you. If your matter happened here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. I hope you have a wonderful day. Take care, everybody. Bye-bye.